Today we are going to finish up looking at Chapter 3, and we're going to look at Section 3, Chapter 3.3, and we're going to look at applying the Constitution. Make sure that you fill in the notes as we go, so whatever you see read on the screen, you need to put into your notes. Feel free to pause the video at any time to make sure you're caught up, and then when you finish, submit the notes for a grade. Okay? Let's go ahead and get started. Number 1, how have the three branches of government applied the Constitution? Well, A, the legislative branch has expanded the justice system. In other words, the Constitution created the Supreme Court and then stipulated that the legislature could create any lower courts that were needed. So they've expanded the justice system. They've also created the FBI, the NCIS, the Army CID, other branches of the justice system where law enforcement is taking place on the federal level. They have created the executive departments and the agencies. So you have the Secretary of Treasury and the Department of Treasury. You have the Secretary of Defense and the Department of Defense. You have the Secretary of Education and the Department of Education. So they've created all these various departments that administer the laws in those particular aspects, okay, in those particular divisions, okay? And they've also expanded law into new areas. So they've done things like create welfare, they've created Medicaid, Medicare, they have done things like that have expanded law into new areas that had never been considered before. So that's how the one branch, the legislative branch, has applied the Constitution. The executive branch, B, has applied law through executive agreements. Those would be agreements between our country and other countries that don't go through the formal treaty process, and we'll talk more about that in a little bit. They have also created the agencies that then adopt rules to implement the laws. So Congress will pass a law, maybe let's say an environmental law, and they will give a very general description of what they want to happen. Then the Environmental Protection Agency, which is in the executive branch, will then take that law and they will implement rules that then will enforce those laws. And those rules that they implement have the force of law. There are some who say that they should not be able to do that Congress should pass the laws they want, and then the agencies just simply implement those laws. But the way it's done now, Congress passes very vague rules most of the time, laws, and then the agencies implement their own rules to do it. And so that gives the president some latitude to determine how the laws are going to be carried out. And then the judicial branch established judicial review, which is where they can decide whether a law or an act of government is constitutional or not. All right, number 2, what is the difference between a treaty and an executive agreement? A treaty must be ratified by 2/3 majority of the U.S. Senate. In other words, a treaty is an agreement that our country, led up by the president, makes an agreement with at least one other country or maybe several other countries. And then once they make that, it can be a peace treaty, it can be anything like that. Once they make that treaty, then it's brought back, and the Constitution says that that the Senate, which is part of the Congress, has to give their advice and consent, and it would be approved or ratified upon 2/3 vote of the Senate. And so when a treaty is determined by the president, he can present it then to the Senate, and the Senate will vote on a resolution and give their advice and consent. As long as 2/3 of the Senate agrees to the resolution, then that treaty goes into effect and it has the effect of law. And that's the way the Constitution outlined for our president to make agreements for other countries. But in more recent times, presidents have started making executive agreements, which is basically like a treaty, but it does not require ratification in the Senate. It does carry the same force as a treaty. Legislation may be needed to enact the power to empower the government to abide by the terms of the agreement. I'll give you an example. When President Obama was the president, he made an agreement with Iran over nuclear weapons and all kinds of things that were connected to that. It was never presented as a treaty. It was an executive agreement. And so we followed it because that was what we do. And when President Trump became president, he did not like it, and he determined that the Iranians were not following their part, so he got rid of that executive agreement. If it had been a treaty ratified by 2/3 of the Senate, he wouldn't have been able to do that. It would have been locked in law. I want to say This is not a power provided in the Constitution. This is something that the presidents have taken upon themselves because they don't want to go through the process of getting something ratified in the Senate, and because it's hard to get 2/3 of the senators to agree on anything. And so it's easier just to do an executive agreement. And then if they need to pass a law to make it happen as an executive agreement, it only has to be a simple majority. My personal opinion is it should not be done. If we have a system in place for agreements with other countries, and it's called the treaty process. And that's what our founders put in the Constitution. And that's, to me, is the way it ought to be done. But that's just my opinion. All right. Number 3, what is the difference between strict and loose constructions of the Constitution? A strict constructionist is a person who interprets the Constitution by giving the words of the Constitution the literal meaning they had at the time they were adopted and as they were understood by the founders. In other words, if the Constitution says it and it's the way that if it says it, you can do it. If it doesn't say it, you can't do it. Thomas Jefferson was a strict constructionist, so he did not believe that the government could do a national bank because there's nothing in the Constitution that says you can do a national bank. Okay, so that's what a strict constructionist says. You know, if it's in the Constitution and it's what they meant at the time, you can do it. If it's not there and you can't, or it's not what they meant, you cannot do it. Okay. A loose constructionist is a person who interprets the Constitution using the words of the Constitution plus any reasonable inferences that can be drawn from them. So like Alexander Hamilton said, well, the Constitution does explicitly say that the government can lay and collect taxes. Well, how are they going to do that? Well, we need a national bank to do that because we have to have a way to collect them and a place to put them once we gather them. Okay. And so we need a national bank. So he interpreted that meaning as in a loose way, meaning that, well, yeah, it doesn't specifically say we can do it, but it gave us this power. So in order to enforce that power, we have to do this. And so that's the difference between strict and loose constructionist. Now, there's a debate raging today over whether you can be a judicial activist or practice judicial restraint, which is closely connected to the strict and loose construction, but we will talk about that in a later chapter. Number 4, how have political parties, customs, and traditions changed how the Constitution is applied? Well, political parties have influenced constitutional interpretation and led to constitutional amendments. They have proposed constitutional amendments. I'll give you an example. The Civil War amendments. When the Civil War was being fought, and it was close to the end, and right after it was over, the Republican Party proposed the 13th Amendment, which freed the slaves, the 14th Amendment, which guaranteed former slaves citizenship, and the 15th Amendment, which gave former slaves the right to vote. So those amendments were passed, and they were proposed by the Republican Party. In the early 1900s, in the 1910s, you had several amendments to the Constitution that were passed, and they were promoted and put out there by the Progressive Party, which was founded by Teddy Roosevelt. And there were progressives in the Democrat and Republican parties at the time, but Teddy Roosevelt broke away and formed the Progressive Party, and they had kind of played off what the populists before them had done. But they proposed amendments like a progressive income tax. They proposed, which was the 16th Amendment. The 17th Amendment was the amendment to directly elect senators rather than letting the state legislature elect the senators. You had the 18th Amendment, which was prohibition. That was a progressive party idea. You had the 19th Amendment, which was women's suffrage, and that was the Progressive Party's idea that were adopted by other parties and put in the Constitution. So they can influence the way the Constitution is interpreted, and they can also influence it by proposing amendments. Customs have become a part of the way our government operates. So for example, Washington, when he was president, there's a part of the Constitution that says that the heads of the executive departments are to do certain things. And so he didn't, there's no way that there was nothing specified as to how they get those. So he formed a cabinet, which was basically a group of advisors that became the heads of the department. And every president after him kept that policy going. So that was a custom that became set in stone, and it's just the way we do it now. And then we have traditions, which are very similar to customs, but some traditions have become law. For example, Washington set the precedent of only serving 2 terms as president, but FDR broke that in 1940 when he ran for the 3rd term and was elected, and then ran for again in 44 and was elected for the 4th term. After that, they amended the Constitution with the 22nd Amendment, which said that presidents can only serve 2 terms. So sometimes the tradition is then put into law. So whereas it was tradition to only serve 2 terms, they eventually put that in the Constitution to make sure they could only do that. Okay. Number 5, how did the president's cabinet come into being? And we've already talked about that a little bit, but basically George Washington relied on language in Article 2 of the Constitution, talking about the heads of the departments, and he used this to assemble a group of advisors. They became the heads of each governmental department, like the post office back then was a department, and the postmaster was a part of his cabinet. You had the Department of War back then, and so you had the Secretary of War, which was a member of his cabinet, etc. Every president after Washington has appointed a cabinet, and those cabinet members become the head of those executive departments. And so that's how that came into being. They call it the cabinet because they met in the kitchen, and so he called them his kitchen cabinet. That's where that word comes from. What criticisms have some people made of the Constitution? Believe it or not, there are people who criticize our Constitution. That some people say that the checks and balances create gridlock. In other words, it's hard for government to get things done. Gridlock is like a traffic jam. It's hard for the government to get things done because you have the checks and balances. You can't just do what you need to do. Well, our founding fathers created that for a reason. They had seen what a government that could easily do what it wanted to do could do to people when they wanted to. And they did not want to have a government that could easily do things, that could easily overpower people. So they created a system that would create gridlock to keep it from being so strong that it could overpower the people. Okay. They say that the Constitution falls short of contemporary democratic standards, like things like the Electoral College and things like that are not exactly one person, one vote. But remember, we are not a democracy. We are a republic, and those things are in place to protect the minority, the people who are not in the majority, the voting majority. And so while they have that criticism, I don't personally agree with that criticism. The president should be directly elected by the people. If you do that, only the coastal cities on the east and the west coast are going to elect the people, be president, and the small states in the middle aren't going to ever have a say. And so that would trample over their rights. Proportional representation would be more fair. Rather than winner takes all in our congressional elections, maybe we should elect them based upon proportion. So if maybe have a statewide vote, and say if this party gets 40% of the vote, then 40% of the representatives from that state are from this party. Another party might get 30%, so 30% are from this party. But it would allow third parties to step up and would give people more equal representation. I don't know that I necessarily agree with that, but I don't necessarily disagree with it either. Okay. All right, that's it. Make sure you submit these notes and do any work that might be related to it. Have a good day.